Hello friends, a very warm welcome to Ansarkari. I am Vikas Bhardwaj. Continuing our understanding on different topics and subtopics with respect to Max Weber in sociology, which is very much applicable in understanding the themes for not only sociology optional but also for general studies in some ways as the complexity of the examination paper is increasing over time. So let's understand that what is Max Weber saying on law with the view, or you can say the prism of rationalization, because Max Weber is following such a, I should say, a methodological process and a way that it has a substantial bearing on understanding of sociological concepts. In the beginning, he says that primitive law, which he is calling as an irrational stage, he went on to convey that there is no differentiation, or what the term he is using is undifferentiated norms, because in the beginning there is no distinction in primitive society between civil wrong, the tort, and crime. For example, land dispute versus homicide, it is handled in a similar way. I would like to take you here in understanding ancient Indian society and ancient Indian civilization, where law and legal norms, they evolved over a period of time and they were codified by the time of Gupta rule. And in that context also, it was uh, at times based on Varna system as reflected by Manusmriti, and they were more harsher for the discriminated, or one can say underprivileged, or one can say slavery and women groups, including Chandals and Shudras, rather than the upper caste and upper classes. And we also see that there was no rationality in a complete manner reflected even in dispensation of justice by the king. But there was an official machinery. So, like the Weber says, no official machinery, and vengeance dominated and no procedural formality. It is not like that. Even in India, in the ancient times, Panchayati Raj system had a kind of a divine and a custom-based law, even for different groups within the Hindu society. Leaders virtually unrestrained in punishing followers. This is more true because when we say with respect to feudalism, that is very true. So Weber traced development from this irrational stage to the rational legal procedure. That is with respect to the Western world, and only in the West, he's saying, it did a systematic rational theory of law emerge as per Weber. Because in an Indian system, when we talk about the law, then it is both Hindu law and Mohammedan law, Mitakshar and Daya Bhag system, and so forth. So stages in the development of law, development of rational law, I would say more clearly, because this is what actually from irrational to rational, that is what we are moving towards in societal manners in the Western world. So charismatic legal revelation. So that is what he is saying, that there will be a kind of a system emerging, a procedural system emerging, and there will be law prophets. That means there would be a kind of a logical, rational based social system in which leaders would be there, or there are a class of people who are coming up with such understanding that there must be a kind of a rational and a nature based law. So empirical creation is there by honorary legal officials. Even if I speak about the modern times, then the France, the codification of law was there uh, by Napoleon, and that's how even later on the US is also adopting the same. Imposition of law by the secular and theocratic powers, as the church power got declined with time and also with the coming up of enlightenment, and also later on ideas of humanism, church powers got retreated. So in the modern stage, there is a systematic elaboration and a professionalized administration of justice. That is very true, and that is why even in India, when the British came to rule India, then also there is evolution of modern legal system and modern judicial system. There are external versus internal forces. For example, external pressures like rationalizing economy, as we already studied about the economic setup, how there are both non-economic and economic factors which are responsible for the same. And even we would say that even religion is a very, very big factor as far as the Eastern world or societies in India is concerned. Internal factors are very decisive. For example, professionalization of legal profession, which is there in the Western world, even today's time, when we say that India must become hub of arbitrary system and India must become hub of international, judicial norms, then we look forward to countries like Singapore, Dubai, Hong Kong, and even certain cities of the Western world, which are actually doing a great torchlight kind of thing as far as legal profession is concerned. So types of legal training he is talking about, like apprentices, like in India also we say apprentices learn from masters during practice. That is how legal practice starts. Produces formalistic law. Formalistic law means that there is a set precedent, there is a set pattern, and there are set norms which are set up, and that's how they are being repeated when the same kind of crimes are being happening, same kind of dispute being arising. Because practically useful precedents they are going to help. This is the goal, and not a comprehensive rational system. Then no legal system actually would survive. That is how sociology comes into picture. So there are bound to be specific issues. There are no general, or you can say there are no two issues are exactly same. There are specific issues and maybe a general overall scenario, and a systematic law is very crucial to understand this point. Academic training is the key to rational law. This is taught in special schools in the Western world and also in India also, like we talk about national law universities. An emphasis on legal theory and science. They produce abstract norms. That means there is a whole legal parlance. In legal parlance, you can say a legal vocabulary and a legal whole taxonomy is being created, which is rigorous. Why? Because there is no scope for any kind of deviations by your own whims and fancies. It is very formal because the language is very classical and it is a very heavy language, and it is very logical. It has to be interpreted in a certain way, and it is general because that's how a new interpretation may come up if it is justifying all constitutional values and laws. And it is not precedent bound means that there may be a precedent, but then it is always supposed to be challenged, and court always have got revisionary powers. So characteristics of a rational legal system, that every decision, that's what Weber is saying, every decision that is applicable of abstract propositions to concrete cases. They may be taking up any kind of scenario, hypothetical situation, but the justice must be done and the concrete cases to be there. Decision must be logically derived from abstract propositions. So there are hearings, there are discussions, there are debates, there are counter arguments, but then at the end of the day, logical, uh, logical proclamations of decisions is there. Law must be treated as a gapless system of propositions. There must not be any gap. It must not be seen to be perceived biased. It must not be carrying any kind of stereotype or any kind of illegality, and it is applicable to all social sections. When we are discussing all this, you please keep in mind Indian judiciary, whether it is the district level, whether it is the state high court, I mean to say, or even the Supreme Court. So law as a rationalization is very important factor because it is promoting rationality in society, and it is vice versa. Law evolved from cultural norms. That is very true. When we speak about India, then Indian cultural values and plurality and society, it has played a very important norm, and it is adjusting itself to the modern times. Also, you think about many social issues which are not there and which have not been talked about in our judicial system and also in our constitution, but still we are able to handle them. And structural formal laws are being there. Actors increasingly constrained by the rational legal system because there are different set of components in society, and then when we try to bring everyone into the rationalized formal legal system, then society definitely responds and it changes. Yet Weber stresses the actor's role. That means society's role, actor, individual, society, different elements of society in emergence and the change of law. That is also very true. So law, when we say law means the part of general process of rationalization in the West. In the West, part that means law is actually when you say as a subset of the whole system in the West, because West is becoming more and more rationalized, and law is playing a very important part into this. So if I say a question to you like the way we were talking in the last uh, lecture also, if the craft training produces practical precedents and academic training produces abstract rational law, Which system better balances justice with accessibility? What is your opinion? And keep in mind the Indian conditions. I repeat the question: if the craft training produces practical precedents, and because you are learning, you are practicing, you are studying, and then you are seeing the precedents, and academic training is producing abstract rational law, which system better balances justice with accessibility? Just try to think, and we will discuss in our personal interaction also. So thank you very much, and we'll see you with the next subset in our next interaction. Till then, keep revising, have a strong faith, and try to look forward with confidence and consistency in order to get success in your goal. Thank you very much.